Property disclosures, the real estate professional's guide to reducing risk. Page 6, negligent advice. Negligent advice imposes liability for giving incorrect professional advice when the agent should have known the advice was wrong. Gerard versus Peterson, 448 Northwest 2D 669, Iowa, 1989. The court rules that an agent who casually advised buyer that it probably wasn't necessary to include a financing contingency in the purchase agreement was liable for giving the buyer negligent advice. Reliance on statements made by the seller. The question often arises as to the extent a broker may be liable for incorrect statements made by the seller concerning property condition issues and then relayed by the broker to the buyer. Court cases support the theory that a broker, in general, may rely on statements made by the seller unless he or she has observed or otherwise knows of facts or conditions in the property which give him reason to believe the seller's statements are false. Hoffman versus Connell, 108 Washington 2D 69736 P2D 242 1987. The court characterized brokers and salespeople as marketing agents and explained that brokers have no duty to verify a seller's independent representations unless they are aware of facts that tend to indicate such representations are false. Other bases of misrepresentation liability. Article 2 of the Code of Ethics and Standards of Practice of the National Association of Realtors addresses misrepresentation issues. Members violating Article 2 are subject to board disciplinary action. Article 2 states that realtors shall avoid exaggeration, misrepresentation, or concealment of pertinent facts relating to the property or the transaction. Realtors shall not, however, be obligated to discover latent defects in the property, to advise on matters outside the scope of their real estate license, or to disclose facts which are confidential under the scope of agency or non-agency relationships as defined by state law. Amended 1/00. Licensing Act liability. Many states have express statutory or regulatory prohibition of misrepresentation in the State Licensing Act and rules and regulations. Licensees are subject to license law disciplinary action and could have their licenses suspended or revoked in states that provide for such Licensing Act liability. Page 7. Consumer protection laws. Many states have passed legislation that expressly prohibits consumer fraud, intentional or negligent misrepresentation, or unfair and deceptive trade practices. Statutes may permit the recovery of 2 to 3 times actual damages. Real estate professionals should determine whether such a statute exists in their state and whether it applies to the real estate industry. Vermont High Court holds real estate company liable to homebuyer under that state's Consumer Protection Act. Carter versus Gugliuzzi, 716A 2D 17 VT 1998. A California attorney purchased a home in Vermont and shortly thereafter noticed a number of problems with the home. She claimed the hardwood floors were in poor condition and that half of the pond was actually located on the neighbor's property. In addition, strong winds had damaged the property, causing broken windows and toppled trees. The buyer sued the seller and the real estate agent for fraud, negligent misrepresentation, and breach of contract, and the real estate agent for violation of the Vermont Consumer Fraud Act. The sellers and the brokerage firm were found liable for $30,624 for wind damage and various misrepresentations, and in addition, the sellers were found liable for $19,700 for misrepresentations about the pond and other matters. The Vermont Supreme Court upheld the decision and stated that the word seller includes real estate brokers who engage in residential real estate transactions, and that the transaction fell under the VCFA. Duty to disclose. Buyer representative had duty to disclose to buyer that most of backyard had been sold to another prior to closing. But neither seller nor listing broker had such duty. Parahu versus Mancini, 698 Northeast 2D 1005, Ohio Court, APP 1998. There seems to be a judicial trend toward careful analysis of who represents whom in a real estate transaction. The Ohio Court of Appeals made it clear that in Ohio, the property disclosure duties owed by a licensee to a buyer can be very different depending upon whom the licensee represents. The sellers sold 62 feet of their backyard to the state of Ohio in February of 1995. The deed was dated April 27th and recorded on June 7th, 1995. In early April, after they entered into the agreement with the state, the sellers listed the house for sale. On April 30th, 1995, the buyers entered into a contract to purchase the property. They were represented by a buyer's agent. The survey depicted the property prior to the conveyance to the state, but the other closing documents, such as the title insurance, mortgage agreement, and deed, contained the accurate legal description subsequent to the sale to the state. The buyers became aware of the situation in August when they were notified that excavation was to begin.